What are my privacy rights for workplace biometric data? Imagine going to work and using your fingerprint or face to clock in or access secure areas. Have you ever wondered what rights you have over that personal data? Today, we're going to break down what you need to know about your privacy rights when it comes to biometric data at work. Biometric data includes things like fingerprints, facial scans, voiceprints, or iris patterns. Employers might collect this data for security, tracking time, or safety reasons. But there are limits to how they can do this, and your rights are protected by laws. At the federal level, there is no single law that specifically covers biometric data in the workplace. Still, some laws come into play. The Americans with Disabilities Act requires employers to keep medical and biometric information confidential and separate from regular personnel files. If biometric data is collected as part of a health program, the Health Insurance Portability and Accountability Act applies. The Genetic Information Non-Discrimination Act protects against misuse of genetic information, which can sometimes overlap with biometric data. Most protections come from state laws, some states requiring employers to notify employees before collecting biometric data. They also need to get written consent and explain how they will use and store the data. For example, Illinois has the Biometric Information Privacy Act. It says employers must give clear notice, get written consent, and follow strict rules for data retention and destruction. Employees can sue employers if these rules are broken. Other states like Colorado and Washington have similar laws. Colorado requires employers to get consent before collecting biometric data and limits the reasons for collecting it. Employers must have a written policy about how long they keep the data and how they protect it. Washington requires notification and consent before storing biometric data for commercial purposes, not for security. Employers must also take steps to prevent unauthorized access and destroy data when it is no longer needed. Employers are generally required to keep biometric data safe and only use it for the purpose it was collected. They should not share it with third parties without your permission, unless required by law. When your employment ends, your biometric data should be destroyed unless there is a legal reason to keep it. If you believe your privacy rights have been violated, you can file a complaint with a state agency or even sue your employer. It's a good idea to review your employer's policies and notices about biometric data collection. If you have questions or concerns, ask your employer for more information or seek legal advice. In summary, your rights include being informed about collection, giving or withholding consent when needed, having your data kept secure, and having it destroyed when it's no longer necessary. These protections come from both federal and state laws, and your specific rights depend on where you work.